My name is Joe Zikas. I'm with NewHomeNotebook.com. I'm sitting here with Lloyd Gussis, who's an attorney who concentrates his practice in real estate.
Large project, lawyers who represent the developers and developers themselves are not necessarily going to do anything for me differently than they're going to do for everybody else. For example, real estate taxes. Typically, and this is pretty much not only big developers but small ones, or big projects but small ones as well. The developer and his lawyer decide how they're going to handle taxes. They're either going to wait until the bills come out and prorate then. They're going to take a percentage of the purchase price and have deposits made at closing.
It's really a question of price, isn't it?
It could be, yeah. But remember that the tax bills don't get divided for a year after the declaration's recorded. So, but what I'm saying is that because they don't want to do something for me and something for the next guy and something for the next guy that's all different and makes their accounting practice, if you will, a lot more difficult when the actual bills come out. They basically say, this is how we're doing taxes, and unless they are desperate to sell a unit, they will typically stay with that. So any modification that you make in terms of taxes, in terms of the way they're going to do it, they're not going to agree to it.
Right.
What sometimes you need to do is modify things to make it clearer by saying, they say, well, the buyer will pay the seller. It would be nice to say that the seller is then going to make the payment on the taxes. So you can add that, and that's something that they'll agree to. But in terms of the actual formula as to how they're going to do it, usually that's off limits. Doesn't mean you don't ask for it, but it's surprising when they agree.
What kind of things is there latitude to negotiate on?
The thing that's most important to me, and I've seen it happen, every single developer's contract does not necessarily have a closing date. What they have is...
Well, sure it does. It says whenever they feel like closing.
No, what they have is an estimated completion date.
Right.
We estimate completion will be by October 31, 2009. But then, of course, they use the next page of the contract to tell you all the things that will be excuses for them not to finish by then. And oh, by the way, the closing is going to be when the unit's substantially complete, and they give you so many days' notice. So the main thing on every single new construction contract I do, unless the unit's already, it's new construction, but it's already completed, is you need to have a drop dead date. Because the way those contracts read, if you sign one, you're in it forever. So if at the project, you're anticipating that you're going to close in December of 08, you're still in the deal in December of 10.
We have a commenter on our website who's in exactly that situation.
Again, I've had people call me in that situation, and when there's no change to the contract, it's an open-ended deal. And obviously people's lives change, circumstances change, plans change. And I think there needs to be a date within which the buyer can say, I can't wait any longer. You told me it was going to be April of 09. Initially when we talked and we put it in the contract, now my lawyer has asked for a drop dead date and you've said November of 09. We are now in December of 09 and you still haven't touched my unit, or you're still a month or two away. I can't wait any longer. I need to cancel.
What's realistic to ask for depending on the project, say a large project?
Typically, and here's the mentality. The seller wants to sell the unit once. So when they talk about drop dead dates, they want a date so far in the future that if Chicken Little got hit by the sky, they would still have this project done. Now maybe in today's environment that's a little bit more difficult, but so when you want a date from them, and remember, the buyer is relying on what the seller's broker is telling them in terms of when the unit will be complete. So they hear...
Well, I remember 900 South Michigan where that deal went on for 8 years before.
Oh yeah.
Before units were finally delivered.
And what happens is they hear a date, and that's the date they have in their head. And of course they've got a lease that expires at a certain point in time. They're getting married at a certain point in time. And the problem is with new construction, it's just really, really uncertain for so many reasons. And I think the only way the buyer can protect himself is to say, look, here's the date you told me. I'm willing to give you X amount of months, and I'll answer your question in a second, beyond that. But if you don't have this done, and I decide I need to leave at that point in time, I need the right to not only get out, but to get my money back. Developers, you play it by ear. I mean, a lot of it is the client who's going to dictate that, because what you basically say to the client is, look, they told you March of '09, reasonably, how long can you wait beyond that? What are your circumstances? Which of course will dictate in a lot of circumstances what exactly they want. But if they said, well, I'm flexible and whatever, I'd probably say 4 or 5 months. And then of course get responded with the 1 year and everything else. The one thing that I try and eliminate from the contract is there are references throughout of excuses as to why the developer won't be done. Labor shortages, work shortages, acts of God, you name it, it's an excuse.
Yep.
I don't want to hear from any of
that's
that.
been on the books
Absolutely. But I try and eliminate that by saying, if for any reason other than the buyer's fault, the unit's not completed and we haven't substantially completed and we haven't closed by this date, thereafter we have the right to cancel.
So a drop dead date is a drop dead date.
Exactly, and I don't want to know from your problems, I have my own.